Hello and welcome back to another video. In today's video, we will be looking at alteration of a will. We will look in depth as to whether a will can be altered and what are the consequences. Stay tuned to the next slide. Can a will be amended? According to Section 21 of the Wills Act 1837, yes, a will can be amended. This can be done by using a codicil, and the amendment must be executed as a will. So, therefore, any alterations must be initialed by the testator and the witnesses, and Section 9 of the Wills Act must be complied with. Let us now look at whether or not an alteration is valid. The general rule is that unexecuted alterations are presumed to have been made after the will was executed, and therefore any alterations made after the will was executed will be deemed invalid. However, there's an exception where an alteration made after the will was executed, if there is evidence of a witness statement or an affidavit that the alteration was made before the will was executed, then the court can deem this as a valid execution. What constitutes an invalid alteration? 1. Where the original text is still apparent, the alteration is invalid. Where the original word is not apparent, the alteration is invalid. And 3, where there is a blank space and the substitution amount, the alteration may be valid. There are exceptions where extrinsic evidence of no intention to revoke is provided, or there is an attempted substitution. Stay tuned to the next slides. I will be going through some examples with you. Let us now look at a few examples of the alteration. First example, I give £100 to X. Now we can see that the £100 has a line through it, and there is £200 written above it. The rule is, where the original word is still apparent, the original amount stands. So the answer is, X will get £100. The next example is, I give blank to X. The rule is, where the original word is not apparent, X will get nothing. So the answer is, X will get nothing, and the will be read with a blank space. The final example is, I give £200 to X, and there's a blank space above it. The rule is, where it appears to be a blank space and then a substitution below, the court may decide that the intention to revoke the original gift was conditioned on the substituted amount. Therefore, X will get the £200. It must be noted that if a substitution is invalid, it is where the original gift can be ascertained by extrinsic evidence. So, for example, the person who is challenging the will provides a copy or a draft will. This is called the doctrine of conditional revocation. The effect will therefore be that X will get the original gift, whatever is under the blank space. However, If this is not sufficient, so if the evidence is not sufficient, then the court will presume the substitution to be valid. I hope these examples provide further clarity for you. Stay tuned to the next slide. Let us now recap finally. So we've looked at alterations of a will and consequences of an alteration being invalid, and whether or not a will can be amended. So yes, a will can be altered. It is presumed to be a valid alteration if it is executed like a will. Unexecuted alterations are presumed not valid unless the exceptions that we discuss applies. It is important to note that if an alteration is made and the original words are still apparent, that alteration is not valid. A quick tip is that alteration is a popular question for interviewing and advising a client in your SQE2 exam. So pay great attention to this topic. Thank you for watching this video. Please continue to like, share, and subscribe for more videos.